Hi, everyone. I'm Cristina Corteva, Executive Director of the Sno-Isle Libraries Foundation. I'm pleased to welcome you all to today's presentation. Thank you to those of you who joined us for our webinar in April. We are delighted to have Sarah Propst, attorney with Galloway Law Group, once again as our featured presenter. If you didn't attend the April presentation, I highly recommend that you watch the video recording on our website, as Sarah covered a lot of important information about creating a will. Today, we have a record number of over 1,200 people who registered for this webinar. This is amazing, and we are so glad that you are finding these presentations helpful. Before we begin, I'd like to share a few quick announcements. First, on behalf of Sno-Isle Libraries, I'd like to thank everyone who participated in last week's important election. The Sno-Isle Libraries levy was on the ballot and got approved by the voters. With this approval, the library will continue to provide welcoming spaces where people can learn, connect, and discover. I invite you to visit your library to explore all that is possible. If you're new to the Sno-Isle Libraries Foundation, the most important thing to know about us is that the Foundation is the nonprofit fundraising partner of Sno-Isle Libraries, and our mission is simple: to ensure that our communities have strong and thriving libraries. The Foundation helps fund a wide range of library programs and initiatives in both Snohomish and Island counties, including early and adult literacy programs like summer reading, which is happening right now, as well as supporting the library collection, building improvements, and so much more. There are many ways to get involved, so please reach out to me or to our philanthropy officer, Carrie Dirk, if you're interested in supporting your library through the Foundation. One way to show your support is to consider including the Sno-Isle Libraries Foundation in your estate plans. When you do that, you automatically become a member of our Legacy Giving Circle and will receive special perks such as invitations to upcoming events. If you're considering making a legacy gift, please let Carrie know and she'll be happy to follow up with more information. Lastly, August is National Make a Will Month and a great time to put your affairs in order. The Foundation has partnered with Free Will, a free online tool that guides you through the process of creating your will or trust. It is secure and easy to use and helps you create a plan that reflects your wishes. That said, while Free Will may be a helpful tool for many of you, it doesn't replace advice from an experienced attorney, and we always recommend that you consult with an attorney or financial advisor on major life decisions. And just a few final reminders. Please know that today's webinar is being recorded and you will receive an email with links to the video recording and slides after the presentation. If you have a question, please use the Q&A box, not the chat, to submit it. If we have time, Sarah will answer questions at the end. And if you see a question in the Q&A box that you like, please click on the thumbs up sign to upvote it. This will help Sarah see which questions rise to the top. When you sign off, a brief survey will pop up on your screen. Please take a quick moment to complete it. These surveys help us improve our presentations and inform future topics. Those of you who complete the survey will be entered to win several gift cards to local bookstores. With that, I'm going to turn it over to Sarah, who will walk us through the probate process and steps we can all take now to make things easier for the people we care about.
Thanks, Christina. Sorry, I need to share my screen here. Okay, does that look good? Okay, thanks, Christina, for the great introduction. I'm Sarah Propst. I'm an estate planning, probate, and estate litigation attorney with Galloway Law Group in Lake Stevens, Washington. This is the second installment of my estate planning webinar series for the Sno-Isle Libraries Foundation. And as Christina said last time in my Estate Planning 101 webinar, I covered the basics of estate planning, including why and how to create a valid will in the state of Washington, plus other mechanisms that you can employ to make sure your wishes are carried out after you die. So this presentation is about the probate process. It's going to be a little heavier and more legally intensive than the last webinar. Estate administration can be a complex process and there is a lot to cover, but please don't worry about trying to remember everything. The goal of this webinar is just to teach you what generally happens between the moment someone dies and the moment their property reaches the people or the organizations they intend to receive it. So I'm going to answer the most common questions I get from my probate clients to help you learn when and how to administer an estate, when to talk to an attorney, and when and how you can do it on your own. I'm also going to give you some tips and tricks to help you make an estate plan for yourself that will prevent the need to have your estate administered at all through the probate process. If you know someone who missed the opportunity to sign up for this free event, please let them know. I'll be hosting another one in the near future. And as a reminder, as Christina said, please put all your great questions in the question and answers box at the bottom of your screen. Because if we have enough time, I'll be answering some of the top voted questions at the end of the webinar. I'm also happy to answer all your individual questions in a one-on-one meeting in my office or by Zoom. I also remind you, please do not put any personal information in the Q&A or the chat box because your messages are not private. Anyone can see them. And lastly, I want to remind you that this is for general information purposes only. And while I am a lawyer in the state of Washington, I am not your lawyer, not yet. So let's get started. Before we start, I do want to acknowledge that death is difficult. Losing someone we love can bring grief, confusion, and a lot of other, sometimes unexpected emotions. And those emotions can make it especially hard to think about the practical and legal matters that follow. Today, we're going to talk about some of those matters, including what happens to a person's property, debts, and legal affairs after they die, and what their loved ones need to do next. But this is not meant to take away from the human experience of loss. Instead, our goal is to make an unfamiliar process less intimidating and more manageable when the time comes. You do not need to know all the answers today, and I'm not going to give them to you. Our goal is simply to understand the general process of what comes next, why it matters, and where to turn for help when it's time. First things first, once death has been officially pronounced, you need to take a breath, okay? You do not have to solve the estate today. You have plenty of time. Your first priority is to take care of yourself. And when people call my office and it's been 1 day or 3 days or a week since their loved one passed, I tell them, please, please put down the phone, take care of yourself, and call me when you're ready. You don't need to empty the house today. You don't need to call every relative. You don't need to pay all the bills. You don't need to divide up belongings, sell the car, close accounts, start giving things away. No, don't start doing that today. Your first job is just to take care of the immediate situation. That might include securing the person's home, vehicles, pets, and known valuables, but not much beyond that. Then what? Over the next few weeks, not minutes or hours or days, you can notify close family and friends. You can contact the funeral home and make arrangements. You can secure the person's home, vehicles, pets, and valuables. And then you're going to want to obtain a death certificate. The death certificate is the first piece of our puzzle. What is a death certificate? A death certificate is the official government record of a person's death. It records important information, including the person's name, the date and place of their death, and the cause of death. So how do you get one? In the state of Washington, the funeral home, mortuary, or whoever is arranging the disposition of the body is typically going to help you order certified copies of the death certificate from DSHS. You can also obtain certified copies yourself through the State Department of Health or your local vital records office. Why do you need it? The big reason is the death certificate is the prerequisite to getting proper authority over the person's affairs. You will likely need certified copies of the death certificate to notify organizations of the death and to transfer or close accounts, including banks and financial institutions, life insurance companies, retirement accounts and pensions, government agencies, creditors, utility companies, whoever needs to know. When you order the death certificate, you should get several certified copies, but you don't need dozens. You can usually use one certified copy for multiple purposes, and some organizations will return the original after they process it. So usually 3 to 5 copies is plenty, and you can always order more if you need to. Okay. So now you have the death certificate, you've taken a little bit of time for yourself and for your family. Now you can start looking for the estate planning documents. People's estate plans are highly personal, so sometimes they're difficult to find. Where should you look? Check their home files, their desk, their filing cabinet, their home office, their important papers folder, the glove box of their car. Check their safe or their safety deposit box or any sort of fireproof box they might have in their home or filing cabinet. Check with financial institutions for safety deposit boxes, as I said, or records that might be held by their financial advisor or a company that is running their trust if they have a trust. The person might have given copies to a trusted family member or a friend. They might have digital copies on their computer or in the cloud. They might have emailed copies to somebody in your family. If there is a trust, if there is a professional fiduciary involved, they most likely have a copy of the documents, but not necessarily the original. You might also look for an estate planning checklist, a list identifying where documents, accounts, insurance policies, and other important information are located. And lastly, try contacting their attorney if they had one. Important note here, please do not start calling around to all the law firms near you trying to find the will, because it will not help you. Attorneys cannot talk to you or disclose whether or not they have somebody's will unless, number one, you can provide a copy of the person's death certificate. Number two, you, the caller, are the person named in the will as the person's personal representative. And three, you produce valid photo ID proving that you are that person. You might be calling around and you might think that a law firm is being rude by refusing to speak with you, but they aren't. They are following the law and protecting their clients' private information. So before you call, make sure you have what you need. So while we're talking about the estate plan, which for most people is a last will and testament, let me take a moment to bust a common myth. This is a question I get a lot. You know the scene from the movies. Everybody gathers in a lawyer's office. The attorney dramatically opens the will and announces who's going to get what. But that is Hollywood. That is not probate. There is no formal reading of the will required by Washington law. And in fact, only certain people are entitled to know what's in someone's will at any point. This can include beneficiaries named in the will, heirs who would inherit under the default laws of what we call intestacy, so if you don't have a will, certain creditors or other interested parties, and whoever else the law entitles to notice. So the takeaway is that being a relative does not automatically mean that you're entitled to receive a copy of the will or know what it says or participate in the administration. So let's pause to reiterate. When you are dealing with the aftermath of a loved one's death, don't panic. Don't start distributing property. Death creates a legal process. And your job right now is to identify and preserve the contents of the estate and figure out who's entitled to what and how to get it to them at a later date. Okay, so hopefully at this point in the process, you have either found the will or you've determined after a diligent search that there was no will. So let's use what we do have to determine whether probate or another estate administration process is going to be necessary. A well thought out estate plan, by the way, is one which ideally avoids the probate process by automatically transferring any assets that would otherwise require probate to transfer. And we'll get to that later on. And we touch on some of those tools in my estate planning 101 seminar. So if you did not find a will or you didn't find any other estate plan, don't worry, because there are default rules for how to proceed that we will cover as well. First things first, I've been saying the word estate a lot. What does estate mean when we say estate plan? Well, when you hear the word estate, you're probably thinking of something like this beautiful picture, a grand, palatial royal estate with a big house and fabulous gardens. And if you are lucky enough to have a castle like this, then it will be part of your estate when you die. But when we say estate in the context of probate, we're talking broadly about a person's property and their obligations at their time of death. So the estate is the collection of everything the person owns, is owed, or owes at the time of death, which must be handled and distributed through the processes established by Washington law. There are a few ways to go about this, and the first is known as probate. In Washington, not every estate needs to be probated. However, it's important to keep in mind that if there is a will, the will must be filed with the clerk's office of the Superior Court of the decedent's, that's the person who died, the decedent's resident county at death, regardless of whether or not the decedent's estate is going to be probated. The process of probate, however, can be used to rally and distribute the property of the estate, whether or not the person had a will. Okay, what is probate? Essentially, probate is the court-supervised process that we use to validate a will, so prove that it's legitimate, identify and protect the assets of the person's estate, pay their legitimate debts and taxes, and transfer their property to the people entitled to receive it. Now, I am a big history person, so I'm going to give you a brief history of probate. Probate is not a modern invention designed to make death complicated and your job difficult. It is an ancient legal solution to a very old problem. How do we transfer a deceased person's property in an orderly and legally recognized way to avoid disputes and other issues? The process of probate is older than the United States, and it's even older than the English common law. Societies have long needed a process for determining what happens to a person's property after death. The idea of a last will and testament is one that dates back all the way to ancient Rome. Our probate laws here, like most of our other laws, come from very old English traditions for the most part. In medieval England, the church's ecclesiastical courts developed authority over wills and personal property. And the word probate comes from the Latin word probare, which means to prove. Over time, the English courts developed rules for administering estates, paying debts, and distributing property according to a valid will, or the law of inheritance. And then our American colonies adopted and modified English inheritance and probate practices. And after independence, probate became primarily a state law function rather than a federal one. And today we're talking about the law of probate in the state of Washington. But wait, does everything go through probate? No, absolutely not. People often hear that probate is terrible and should always be avoided, but that is too simplistic. The first question we need to ask is whether probate is necessary or useful for this particular estate. Washington law does not require a probate proceeding to be filed following death, regardless of whether the decedent died with or without a will, i.e., testate, with a will, or intestate, respectively. Probate in Washington is entirely discretionary, and probably only a few % of total deaths in Washington results in a probate being filed. So in Washington, if a probate is filed, it's because someone wants it to be filed, not because the law necessarily requires it. However, probate is a great tool. It is without a doubt the best way to administer an estate where the decedent died holding one, any real property titled in his or her own name, so real estate, a home, or two, personal property, usually cash or investments, titled in their own name whose value exceeds $100,000. Probate is also the best way to deal with an estate where the person died with lots of debt, because it affords you a legal process to wipe away debts with proper notice and after a short waiting period. So now that you know what probate is, let's explore some alternatives to probate to find out whether you need to go down that path or not, and then I will teach you what that path is. Probate is often avoidable. It is not the only way property can move from a deceased person to the people or organizations they want to receive it. You don't need the technical rules or to understand the ins and outs of each of the alternatives we're about to talk about, but I do want you to be generally aware that they exist so you can think about whether they might be useful to avoid probate in your situation. I also want you to know about these options when it comes to your own estate plan so that you can think ahead about how to simplify how your estate can be handled when the time comes. I talk about these options as well, maybe a little more in depth in the first installment of this webinar series, which was Estate Planning 101. So I encourage you to go watch it if you're interested in learning more about how to set this up for yourself. After we talk about these, we'll get into probate and how that process works if none of these options are available to you. A community property agreement. For married couples, a community property agreement can provide the simplest way to transfer property when the first spouse dies and avoid probate. You should think of it as an agreement between spouses about what happens to their property when the first spouse dies. If the decedent was married and they had a community property agreement with their spouse can record the community property agreement with the county where their assets are located in order to automatically transfer everything to themselves. This avoids the need to open probate until the surviving spouse also dies. This is without a doubt one of the most useful documents you can have to simplify the estate administration process. Beneficiary nominations. A pay-on-death beneficiary nomination is one of the most important concepts you should remember from this presentation, as well as my Estate Planning 101 webinar. Wills and trusts generally do not control an asset that already has a valid beneficiary designation. These are considered non-probate assets. So for our purposes today, which is learning how to administer a deceased person's estate, this means you need to go and find out whether each of the deceased person's accounts already has instructions for who it's supposed to go to or not. if someone was designated directly with the institution as a pay-on-death beneficiary, the account will go to whomever that pay-on-death beneficiary is, no matter what the will or trust says. But if there is not anyone named directly, you will most likely need to utilize the probate process to get that asset transferred. So keep that in mind when you're making an estate plan for the future administration of your own estate. You want to directly nominate beneficiaries with each of your accounts. Automatic transfers. So sometimes probate can be avoided because all the property that the person owned when they died was titled in a way that allows it to pass automatically. So this slide has more to do with real estate rather than bank accounts or other personal property like the last one, but it's a similar concept to that pay-on-death beneficiary nomination that we just discussed. So one Washington-specific example of an automatic transfer is a transfer on death deed. I talked about this in my last webinar. A transfer on death deed can allow qualifying real property to pass to a designated beneficiary at death without any other action needing to be taken. Another example is if you own property with the deceased person as joint tenants with the right of survivorship. When you have an ownership arrangement like this for a piece of property that includes survivorship rights, the deceased owner's interest passes to the surviving owner rather than having to be handled through the probate estate. So again, we're intentionally keeping this high level. These arrangements have certain technical requirements and exceptions to when they can be used. And just putting two people's names on an asset does not necessarily mean it will pass automatically. It has to be with right of survivorship. So the important thing for you to understand here is the concept that sometimes the ownership document itself determines what happens when the owner dies. So when you're trying to figure out how to transfer a deceased person's property, look it up and see if they titled it so that it can transfer automatically. And if they have, your job might be finished before it even begins. Trusts. If you watched my Estate Planning 101 webinar, you know that I am not the world's biggest fan of trusts, but they certainly have their place and they can be very useful for avoiding the probate process, so long as they are properly funded, okay? Simply signing a trust document does not necessarily keep assets out of probate. The assets have to be properly transferred to the trust or otherwise arranged to pass under the trust. This is a process of funding, is moving the property from yourself individually into the trust. You should probably have an attorney's help with this, but you can do it yourself. When used properly, trusts are a great way to simplify the estate administration process. Essentially, when the person who created the trust dies, the next person in line, called the successor trustee, takes over administration of the trust property, and there generally is not a probate proceeding for those assets because the trust owns them rather than the individual. And the trust is a private entity, basically. So trust administration is a private proceeding rather than a public court proceeding like probate. But like I told you in my last webinar, trusts are not one size fits all. Trust administration isn't automatically better than probate, and having a trust is not necessarily going to help you avoid probate. They can be useful, but they involve their own ongoing costs, responsibilities, and administration requirements. So I will tell you that for most people, a properly prepared will that allows for a straightforward probate is simpler. But if you are interested in trust, I do recommend you talk to a good estate attorney who will be straightforward with you about the pros and cons. I want to take a moment to remind you that when you're doing your own estate planning, remember that you can name charitable organizations to receive assets directly, as well as human beings. A trust, A direct beneficiary nomination or an automatic transfer arrangement is a great way to make sure you're supporting the causes you really care about without having to rely on the probate process to make a gift to charity through your will. Okay, hopefully when you started poking around to see what was what in the administration of the estate, you found some of the tools we've just touched on to simplify the process and make things a little easier on you. But if not, I hope you're thinking about whether you can use any of those things in your own estate plan to save your heirs the headache you're going through now with this estate. Luckily, we have a couple more tricks up our sleeve to simplify the estate administration process in certain circumstances. The lack of probate affidavit and the small estate affidavit. Now, these are easily available forms, and you can absolutely prepare them yourself. But again, I or any other estate attorney would be happy to prepare one for you. A lack of probate affidavit is used when a husband and a wife own a home together. It takes the deceased spouse's name off of title, leaving it only in the surviving spouse's name. And this is important. You cannot use a lack of probate affidavit to transfer title to any other person. It's not a deed. But if the only thing the deceased person had was their house and they owned it with their husband or wife, you can record a lack of probate affidavit with the county to clear the deceased person's interest out. And this achieves the same goal, basically, as the community property agreement we talked about earlier. If you don't have a community property agreement, a lack of probate affidavit can be done after the fact to achieve the same purpose. A small estate affidavit is the other side of this coin. It actually can be used to transfer property to another person, known as a claiming successor. The caveat here is that a small estate affidavit only works for personal property, so anything that is not real estate. And it only works up to $100,000 in value. So these two affidavits can be used separately or together, whether or not there is a will. But if there is a will, you can't use these to alter the will's instructions. They're just the mechanism for carrying out those instructions. If you can transfer all the deceased person's property using these two documents, then chances are there is no need to open probate. So that's great. Okay, fine. None of the mechanisms to transfer estate property that we've talked about so far are available to you. Or maybe there are substantial debts that you want to cut off. So it's time to open probate. How does that work? The first step in the probate process is the appointment of the personal representative. The personal representative is the person legally responsible for handling a deceased person's estate. You should think of the personal representative as the manager of the estate, not the owner of it. The role of the personal representative is called two different things depending on whether the decedent did or did not leave a will. If the decedent left a valid will, it will usually nominate the person they want to serve, and if that's the case, the responsible person is known as the executor. If the decedent did not have a will, then the law sets out a list of people who can ask the court to serve as the personal representative. The law in Washington was somewhat recently changed, actually, to update the priority list of who can serve as personal representatives of estates where there is no will. And again, these are known as intestate estates because your will is your last will and testament. First on this list is the surviving spouse. If there's no surviving spouse, then it's the decedent's children. And if there are no children, the responsibility goes to their parents and so on. You can find that list by looking at RCW 11.28.120, and this will be in my presentation notes. The job of the executor, personal representative, or administrator is the same regardless of what we call it. So we'll talk about those duties, responsibilities, and powers in a minute. But the important thing to remember here is that whether or not there is a will naming someone as the executor. That person has no power to do anything regarding the estate until the probate court gives them the legal authority to do so. All right, what does the personal representative do? Their job is to administer and ultimately close the estate. So that generally means finding and protecting assets, identifying debts and people the decedent owed money to, collecting money that the person was owed by others, paying valid debts, expenses, and taxes, dealing with their property and other assets they might have, notifying the people who are entitled to know. Record keeping is a big one. You want to keep accurate records. And ultimately distributing what there is to distribute to the people who are supposed to receive it. And then you can close the estate. So we'll go through each of these steps. Now, Washington law imposes fiduciary duties on the personal representative. And the representative can be held accountable for failing to properly administer the estate. That's why I emphasized record keeping earlier. We talked about fiduciary duties in the last webinar, and the key takeaway there is that if you are someone's fiduciary, that means you have to put that person's interests above your own, no matter what. And that's true even if they aren't alive anymore. The most important concept to remember is that the personal representative does not own the estate. They're responsible for managing it for the benefit of the people who are legally entitled to it, which might not be you. That's an important distinction. Being someone's child, spouse, or beneficiary does not automatically give you authority to access or control any of the assets of the estate. Only the personal representative has authority, and their authority only comes from being legally appointed by a court. So, opening probate in Washington. How do you open probate? The process is usually a lot simpler than you might think. A lot of people do choose to get an attorney to help them open probate because it generally does require physically appearing in court in front of a judge and asking to be appointed as personal representative. But if you have the right information and a little bit of courage, you can totally accomplish it on your own. There are a ton of resources online and at your local library that you can use to help you through this process, as well as this presentation, which will be sent to you after we conclude here and which will be published on the Sno-Isle Libraries Foundation website. So let's go through now the basic steps to open probate for both testate, where there is a will, and intestate, where there is not a will, estates. First, you need to decide where to file. Probate must be filed in a superior court. So I don't know if you remember your civics about what the various levels of court are, but what you need to know is it has to be filed in a superior court. Usually you'd open probate in the superior court of the county where the person lived when they died, or where they owned real estate at the time of their death. But technically, you can file probate in the superior court of any Washington county. If you don't have an attorney to help you, it's usually best to open probate in the court that's the most convenient for you to physically travel to when necessary. So here's a map of all the counties in Washington to help you decide. I'm guessing most of you, since this is a Sno-Isle Libraries Foundation presentation, live in either Snohomish or Island counties. In Snohomish County, the Superior Court is located in Everett, and in Island County, it's located in Coopville. All right, who should actually go to the court that you've identified and ask the judge for probate to be opened? Is it you? Like we talked about earlier, the estate plan is your roadmap. The will tell you who the executor should be. And if there is no will, the first person on the list prescribed by Washington law, again, would be the surviving spouse. If no surviving spouse, it's the children. If no children, then the parents, and so on. If it is not cut and dry who the personal representative should be, or if the person who's supposed to do the job can't or won't do it for some reason, you should consider meeting with an attorney to help you solve that problem before you try to open probate. Okay, so this is the homework part. You've chosen the court. You've figured out who is going to ask to be appointed. So now you need a written petition to properly make the request to the judge. Judges like to read. They don't like to just be told things verbally. They want you to create a written record that is published to the public in the court file. But don't worry, this is easier than it sounds. Essentially, the judge just wants you to tell them in writing, someone died. Here's who they were. Washington law says this court can handle the estate. Here's the will, or here's the reason why there isn't one. Here are all the people who are legally interested in the estate and where they live. And here's the person asking to be appointed personal representative, me. If you don't want to hire a lawyer to help you prepare your petition, there are, again, lots of resources online and at your local library, which will tell you exactly what to write. There are several good templates available that you can download and fill out. And you can also refer to this slide for all the information you'll need to include in your petition for the judge to grant it. All these slides will be available for you within a couple days. In addition to the petition and the will, if there is one, you are going to need to give the court your oath of personal representative. The oath of personal representative is a sworn statement in which you, the person appointed as personal representative, promises that they will perform the duties of the office according to Washington law. So at its core, it says, I swear that I will perform my duties as personal representative according to the law. And then Washington court rules also require that the oath include a statement that the person is qualified to serve. For example, that they are not under the age of 18, that they are not a person of unsound mind, that they are not a corporation that's disqualified for some reason, or that they are not a person convicted of a felony or a crime involving moral turpitude. So, in plain English, you're saying to the court in writing, I'm legally qualified to do this job, and I promise to do it properly and to follow the law. And remember, being a personal representative is not just a title, it's a fiduciary responsibility. So think of your oath as the official promise that you have to give before receiving the keys to the estate. Important, the oath of personal representative must be notarized. You can take your oath in front of any licensed notary public. If you're getting help from a lawyer, they'll have a notary that can do it for you. You can also find notaries at banks and certain shipping centers like UPS or FedEx. Okay, this is the part people are scared of. What do you actually say to the judge? But there's no need to be nervous because usually you don't need to say much. In fact, in a lot of counties, you can open probate simply by mailing your documents to the court and you don't have to show up at all. But if you do need to make a verbal presentation, you will go into the courtroom, you'll hand up your petition, your oath of personal representative, and the original will, if there is one. And then you're basically just going to read what your petition says out loud. This is not a dramatic courtroom presentation. The judge isn't looking for a speech. They just want to get the answers to the questions on this slide. So here's an example. If the judge asks, they call your name and they ask, why are you there? So you're going to give them this answer. Your Honor, my father, John Smith, died on June 1st, 2026. He was a resident of Snohomish County. He left a valid will dated March 15th, 2020, and it names me, Jane Smith, as personal representative. So I'm asking the court to admit the will to probate and appoint me as personal representative. That's it. You're not there to tell the judge your father's life story or your life story. The petition and the will itself, if there is one, will do almost all the talking for you. Now, again, I realize this is intimidating. If you aren't comfortable doing this on your own, you certainly don't have to. I or any probate attorney would be happy to help you, even if all you want us to do is take care of the presentation to the court for you. Consider calling an attorney if your circumstances are more complicated than what this slide appears to cover. But really, don't be afraid of taking a stab at it on your own. The court is used to it. People open probate for themselves. Well, not for themselves, for their loved ones by themselves all the time. And you can completely achieve it with the right know-how. So you probably noticed that on the last slide, I said you need to present the judge with the original will. In Washington, having the original will is very important, although a copy is not necessarily useless. Why is this? First, the original will is the clearest evidence of the document that the person actually executed. Second, Washington law specifically provides for the filing of the original will with the court after the testator's death. So remember, we talked about you need to file the will with the court whether or not you're going to probate it. And they want the original. The person who has custody of a will, who has it in their possession, generally has the duty to deliver it either to the probate court or to the person named as personal representative or named as the executor. If you only have a copy, it can create additional questions about whether the original existed, whether it was actually executed, whether it was later revoked, and whether it's an accurate copy. But don't worry, if you don't have the original, there are ways around it, but you should consider hiring a lawyer to help you if this is the case. So what does the judge do? If everything's in order with your documents and your presentation, the judge will sign an order which, number one, opens the probate case, and number two, orders the clerk of the court to issue either, and you're going to know these words, either letters testamentary or letters of administration to you as the estate's personal representative. Letters. What are letters? The letters are what you will repeatedly show banks, financial institutions, government agencies, title companies, and whoever else needs proof that you actually have the authority to act on behalf of the estate. If you're personal representative of a testate estate, meaning there was a will, they are called letters testamentary. And if there was no will, they're called letters of administration, but they're the same thing. Remember earlier when we talked about the powers of the personal representative? These letters are the legal document which actually gives you those powers. Here are those powers again. Remember, the personal representative's authority only comes from legal appointment by a court and the issuance of letters. Once the judge signs the order, you should go to the clerk's office and buy at least 3 or 4 copies of your letters, just like you did with your death certificate. And again, you want certified copies, not just regular photocopies. A certified copy is as good as an original, and they are usually reusable. So the takeaway here is your letters are your golden ticket. They're the tool that allows you to do anything you might need or want to do to administer the estate that you're in charge of. Okay, you've opened probate. Good job. Congratulations on getting this far. But now the real work begins. So here is a basic outline of your next steps. And we're going to go through each of them in detail. First, you got to let people know. Washington law requires the personal representative to provide notice of their appointment and the fact that probate is open to certain people within 20 days of being appointed. And you do this by simply mailing them a letter, letting them know, and ideally attaching a copy of your letters testamentary or letters of administration. Now, You need to make sure the estate assets that you are now in charge of are corralled and secured. Now that you have your letters, you can use them to access the deceased person's bank accounts. And once you have access to those bank accounts, you need to use their money to keep things current. The estate still has bills, so you need to continue paying anything that needs to be paid, including mortgage, utilities, property taxes, insurance, HOA dues, any ongoing maintenance that can't reasonably be paused. So don't confuse this person died with the bills stopped, but do feel free to discontinue paying for things that are no longer needed, such as streaming services, subscriptions, or gym memberships and stuff like that. If there's real estate involved and you were unable to take care of those things previously because you lacked proper authority, do these things now. Secure the home and other property, change locks and access codes if necessary, make sure insurance coverage is up to date, protect valuables and important documents, and arrange for pets and other things that require care. Then, if the house is supposed to be sold, you can use your authority as personal representative to enter into a listing agreement with a real estate broker and start preparing the home to be sold. Okay, just like bills don't disappear, when somebody dies, their debts don't automatically disappear either. But Washington gives the personal representative an optional process for identifying and limiting creditors' claims. This is a process of cutting off debts that makes probate so useful in certain contexts. By using the statutory notice to creditors process, you can resolve estate debts now so that the heirs can receive their inheritance with certainty, and hopefully so they can receive more inheritance than they otherwise might. So the first step is to identify all the debts that you know exist and send those creditors notice directly by mailing it to them. And this limits the time for them to respond to 30 days. The second step is to publish the notice in a local newspaper once a week for 3 weeks. So that legally puts everybody else on notice that the person has died, and that if they're owed money, they need to make their claim within 4 months. So logically, you should take from this that probate generally lasts between a minimum of 4 months and maybe a year or more, depending on how complex the estate is. So by giving this notice to creditors by mail and by publication, you are essentially putting a speak now or forever hold your peace notice in the newspaper, but for creditors. So that is a great tool in your toolbox. Now, what happens if a creditor actually makes a claim? Well, first of all, if it was made during the notice period before they were cut off, you need to either pay it in full or negotiate it down. Please remember, you should always pay debts from estate funds, never your own. If a creditor makes a claim late, their claim's bar, and you have no obligation to pay it. Again, I want to make this specifically clear. With limited exceptions, which you absolutely should talk to a lawyer about if they arise, you are never obligated to pay the bills or debts of a deceased person personally out of your own funds. Don't do it. And when you're making your own will, consider including a reminder to your loved ones that they are not responsible for paying your debts out of their own pocket when you die. So, now that you've determined what assets the estate has, what bills need to continue being paid, and what debts can or should be satisfied, you can calculate what is left of the estate to distribute to its heirs. Once you have that number, the net value of the estate, you need instructions for how to split it up between those heirs. If there's a will, it's simple. The people or charities named in the will receive the property that the will states they should receive, whether it's in the form of real estate, personal possessions, or money. If there's not a will, it's still simple. You just have to follow the default rules for what's called intestate succession. We talked about this in the Estate Planning 101 webinar. But the essential pattern is, first, everything goes to the surviving spouse. If there's no spouse, to the children. If no children, to the parents. There's a more detailed list that you should read if this is your situation. But as simple as it might seem, and should indeed be, sometimes you will receive pushback for trying to follow those instructions. The subject of inheritance disputes makes up a lot of my business and could fill several webinars, and we cannot get into it all here. But the important thing to know is that if there is a will, the instructions in the will control, and you cannot act differently from what it prescribes unless all the beneficiaries agree in writing. And if there is not a will, it's not a free-for-all either. There are default rules under Washington law regarding who is legally entitled to receive what from the estate. The personal representative, that's you, has to follow the will, and they have to follow the law, even if they personally don't like it, and even if somebody else doesn't like it. If a problem like this comes up, please do talk to a lawyer, because inheritance disputes are generally resolved with lawsuits. One of the primary benefits, by the way, of making a will in the first place is preventing disputes like this. And when you make your own will, you should consider including what we call a poison pill provision that automatically cuts off and disinherits anybody who disagrees with your instructions after the fact. Okay, you were so close to the finish line. So now that you know what's left in the estate and who it's supposed to go to, you can actually make those distributions. If there's real estate, you'll execute and record what is called a personal representative's deed. Well, similar to a quitclaim deed, but there are lots of different kinds of deeds. And in this case, it's called a personal representative's deed to transfer the property to the intended recipient. If it's money they're supposed to get, then you'll write them a check out of the estate's bank account. And if it is personal property or sentimental items or pets, you will arrange for pickup or delivery. So this is important to remember. Whenever you make a distribution of estate property, no matter what it is, you should get a receipt from the person who's receiving it. This is part of your record-keeping duties. So at this point in the estate administration process, the personal representative should also be reviewing the will to check for any charitable gifts that the person wanted to make and contact the organizations named in the will. The personal representative should then work with that organization to make sure the gift is properly documented and transferred. And this is a good reminder that when you're thinking about your own estate plan, if there is a charitable organization that you'd like to support after you die, a will is a simple and effective way to make a specific gift of property that passes through the probate process we've just described. Don't leave your charitable intentions to chance, okay? You have to give a specific instruction if you want it to happen. Your family might know that you love the library or another organization, but knowing what you would have wanted isn't the same as having legal authority to carry it out. So if you want a charity to receive something from your estate, put that intention into the appropriate legal document, and that way your wishes are clear and your personal representative can carry them out with confidence. Guess what? You're done! If you made it through all the steps in the previous slides, and I know, there were a lot of them, then you successfully completed the estate administration or probate process, and you are ready to close up shop. So you'll do this by sending a letter notifying the parties that are interested in the estate. Then unless they object within 30 days, the estate will be automatically closed. And at that point, you can actually pay yourself a reasonable wage for the time you spent doing the job of personal representative. And you'll be relieved from your duties and responsibilities. Your work is finished. Congratulations. All right. Good job, everyone. That was a lot of information. I know it was a lot, but if you've made it this far, you have done great. We've covered a tremendous amount. And if you're sitting there thinking, there's no way I'm going to remember all of that, that's completely understandable, and I don't expect you to. I'm not trying to turn you into a probate lawyer. I'm just trying to give you a roadmap to help you understand what happens after someone dies, what the personal representative is responsible for, what documents and deadlines matter, and where you may need to look for additional information. So please keep these materials as a reference. And if you have questions after this webinar, or if something we discussed wasn't clear, please leave your question in the Q&A or reach out to me or to my team at Galloway Law Group. The state administration can raise very specific questions, and it's perfectly reasonable to need clarification. But the good news is that as complicated as this can seem at first, estate administration is a very well-established process. There are rules, there are forms, there are deadlines, there are procedures. You're not expected to invent the process as you go. And for many estates, you really can do this yourself. Take it one step at a time. If you aren't sure what to do, slow down, get organized, look at the rules, and ask questions. But the most important thing that I hope you take away from today's presentation is this. The best way to make estate administration easier is to plan your own estate before you die. Think about the person who has to clean up everything after you're gone. The more clearly you've documented what you own and who you want to receive it and who you want to handle things and what your wishes actually are, the easier you're making that person's job. So if you haven't already done so, I strongly encourage you to watch the previous webinar, Estate Planning 101. That's where we talk about the documents and decisions you can make now to make the subject matter of this presentation easier on your family later down the line. And finally, I'd like to leave you with one more thought about charitable giving. If your library has been important to you or your family, please consider remembering the Sno-Isle Libraries Foundation in your estate plan. A gift through your will or another appropriate estate planning tool can be a really meaningful way to support the community, to support publicly available information like this, and to ensure that the library can continue to serve future generations. So thank you so much for tuning in. And of course, thank you to the Sno-Isle Libraries Foundation for hosting us today and making this information available to you guys. And in closing, plan ahead, stay organized, ask for help when you need it, and remember that you can absolutely do this. So now I'm going to take a minute to open up my Q&A box, and we will try to get through a couple of questions before we are out of time today. Okay, so I will remind you, I can only answer general questions. I can't answer questions about your specific circumstances, but I will do my best to answer some of the more general probate-related questions here. So one I've got is it smart to set up a trust for your home to protect it for your spouse in the event of death of a spouse? Yes, absolutely. Absolutely. Different kinds of trusts serve different purposes. Almost any kind of trust can be helpful for if you have enough money to make it worth it, because predominantly what trusts do is help with tax consequences. There is a form of trust called a spousal disclaimer trust, which allows your spouse to, rather than receiving property themselves into their own names and paying a tax on it, they can leave it in the trust and just receive the benefit of the property, like continuing to live in it. So yes, I would say a trust can be a very useful tool, but it entirely depends on your circumstances and the level of wealth that you're working with. Does a person need a will if the spouse will inherit everything? Will probate be required too? Not necessarily. Not necessarily. It kind of it can depend on the composition of the rest of your family. At the very least, if you do nothing else, if you are married people, please do a community property agreement. That will take care of, if everything's supposed to go to your spouse, that will do what a will would do, and it'll avoid probate. Isn't Washington State a common property state? It's a community property state. Is a community property agreement still needed for married couples? Yes, because community property laws cover certain things and not other things. And the purpose of a community property agreement is to gather anything that wasn't captured by the community property statute. So anything that you might own in your own name, such as inheritance, is your own separate property. It's not marital property. You'll capture those things and turn them into community property owned by the both of you. How do you file for transfer on death deed? I very much recommend you have an attorney help you with a transfer on death deed. It is not the most simple thing to do yourself, but it is a great tool to make sure your home can pass automatically to who you want to receive it. Is there a low-cost way to create a trust? No. No, there is no legitimate and good and valuable low-cost way to create a trust unless you are a lawyer doing it for yourself. I mean, they are just risky. They require maintenance. It's not just the creation of the trust, but you have to keep it updated and keep it funded and keep it moving over the course of your whole life to make sure it does its job in the end. Okay. Is a pay on death the same as listing a beneficiary on a 401k or a savings account? It depends on the type of the account. It depends on the institution. Generally, I would say yes, but you want to call and make sure that those designations are the same. Some specifics, I have had a couple questions. This one says, this is great info, but it seems to be focused on married couples. What are some specifics for single adults who have property and investments? It's not really more complicated if you're single, okay? It just means that the first priority person, who would be the spouse, are out of the equation. So we just skip to the next step, which would be everything by default goes to your children. So if that works for you, maybe you don't need a will. If you want to give things to your children, you have more than one kid and you want somebody to get something in particular and somebody to get something else in particular, or you want one to get everything and one to get nothing, then you're going to need a will or an estate plan to make those specific instructions. Look into the default rules and determine from that whether you need an estate plan or not. Not everybody does. What is the time frame for filing the will under Washington law? You are supposed to do it within 40 days. The reason for this is that if you don't file it within 40 days and the person owed a bunch of money, the creditor can actually come in and open probate after 40 days. So you can absolutely file the will after 40 days, but you should prioritize trying to do it within 40 days so that you can avoid the threat of a creditor coming for the estate. What is your opinion on filing a will with the county after death? You must do it. There is a state law to do so. So if your attorney said not to bother, then they are wrong. You need to do that. Domestic partners, there are a couple questions about domestic partners. The rules do differ from the rules for married couples. I recommend you do some research into that. I don't have the capacity to answer that kind of question here, but do know that it does introduce some complexity to the process. I need two wills if I have properties in two different states? No, you only need one will, and it doesn't matter which state that will is in. But if you have real estate in more than one state, you might have to open probate in both states. You use the same will. If you have two parallel probate proceedings in each county where you have real property. And the last one I'm going to answer, because we're butting up on our time here, is how is a reasonable wage for the executor or administrator figured? Usually you can base it on what you make at your job, but if you are extraordinarily well paid, the court might not think that that's reasonable. Also, the beneficiaries have the right to show up and argue that the rate you're trying to pay yourself isn't reasonable. Usually I'll say I see anywhere from like $25 to like $70 an hour. And you have to keep track of your time, write down what you did, when you did it, and how that turns into the number that you're asking for. So those are all the questions that we have time for today. I realize that was a lot of information. I hope that you got some of your questions answered. And if not, then I hope that you will reach out and do some research with this newfound knowledge to find the way forward in your situation. I really appreciate everybody's attention, and tune in next time. Thanks so much.